War used to be armies. Now it's contracts, lawfare, and hostile investments. We grew up learning that war is a clash of nations. You picture tanks crossing borders, soldiers in trenches, and flags raised over conquered cities. We are taught that power flows from the barrel of a gun and rests in the hands of presidents and prime ministers. But that version of warfare is becoming obsolete. The most effective conquests of the 21st century don't happen on a battlefield. They happen in quiet, air-conditioned rooms in Washington, London, and Geneva. They happen in international arbitration tribunals where 3 private lawyers can overrule a nation's Supreme Court. They happen in the fine print of trade deals that classify public health laws as trade barriers. They happen when a hedge fund seizes a sovereign naval ship, not with the Navy, but with a court order. This is the silent takeover. It is a fundamental shift in how power operates on our planet. We are witnessing the erosion of the nation-state and the rise of a new geopolitical order where corporations act as sovereigns in all but name. To understand this, we have to realize that the multinational corporation is not a modern invention. It is a colonial one. The legal structures that allow a company today to sue a country or to police a population have their roots in the 1600s. We need to look back at the ancestors of this autonomy. We need to talk about the British East India Company. This wasn't just a trading firm selling tea and spices. Tea was a state disguised as a merchant, established by a royal charter from Queen Elizabeth I in 1600. It was granted rights that we would consider insane for a company to have today. It had the right to wage war. It had the right to make peace. It could mint its own coin and administer its own justice system. By the mid-18th century, the company had evolved from a trading enterprise into a territorial empire. It didn't rely on the British Army for security. It built its own. At its peak, the company's private military force numbered approximately 260,000 soldiers. To put that in perspective, that was double the size of the British Army at the time. This private force was commanded by officers employed not by the crown, but by the company. They fought wars not for national defense, but for shareholder value. They defeated indigenous rulers at battles like Plassey and Buxar. These were corporate acquisitions, hostile in the most literal sense. The company conquered Bengal, not to liberate it, but to extract from it. The most critical moment in this history was the acquisition of the Diwani in 1765. After defeating the Mughal emperor, the company forced him to grant them the right to collect taxes. Overnight, the merchant became the tax collector. They farmed out tax collection to the highest bidder, extracting wealth from the peasantry with ruthless efficiency. This rapacious extraction contributed to famines that killed millions, yet the company's share price soared. They used the tax revenue from Indian subjects to buy Indian goods to export. It was a closed loop of exploitation. This was the original model of corporate sovereignty, a private entity exercising public power for profit. Edmund Burke, the famous philosopher and politician, eventually led an impeachment trial against the company's Governor General, Warren Hastings. Burke argued that the company had violated eternal laws of justice. He railed against the arbitrary power exercised by a corporation over human beings. While the East India Company was eventually dissolved, its spirit didn't die. It merely fragmented. It evolved. Today, corporations don't need 200,000 soldiers to force a country to submit. They have something far more efficient. They have the Investor-State Dispute Settlement System, or ISDs. This is the musket of the modern corporate soldier. SDS provisions are embedded in thousands of trade treaties. They allow foreign investors to bypass domestic courts and sue sovereign governments in international tribunals. If a government passes a law that protects the environment or public health or raises the minimum wage, and that law hurts a corporation's profits, the corporation can sue. They don't just sue for the money they lost. They sue for lost future profits. They sue for the money they imagined they would have made. And these cases aren't heard by judges. They are heard by tribunals of 3 private attorneys. Kayla, these arbitrators are not tenured public officials. Kayla, they are corporate lawyers who often rotate roles. One day, they represent a corporation in a lawsuit, and the next day, they sit as a judge in a different case. System creates a parallel legal universe accessible only to foreign corporations. It grants them a status equivalent to sovereign states. Let's look at Philip Morris versus Uruguay. Uruguay is a small nation that decided to tackle a smoking epidemic under President Tabaré Vázquez, who was an oncologist. They passed strict tobacco control measures. They required graphic health warnings to cover 80% of cigarette packs. They banned multiple variants of brands like gold or silver to stop the misleading implication that some cigarettes were safer. Philip Morris International, a tobacco giant with revenues bigger than Uruguay's entire GDP, didn't like this. So they sued. They didn't go to the Uruguayan Supreme Court. They went to an international tribunal. They argued that these public health regulations devalued their intellectual property. They argued that their right to profit superseded the state's right to regulate public health. Uruguay had to spend 6 years and millions of dollars defending its right to protect its own citizens. Uruguay eventually won, but it was a Pyrrhic victory. The lawsuit served its purpose. It sent a chilling message to every other developing nation considering similar laws. It said, if you regulate us, we will bankrupt you in legal fees. This isn't just a problem for developing nations. Look at Germany. Germany is a powerful Western democracy. After the Fukushima nuclear disaster in 2011, the German government decided to phase out nuclear power. This was a democratic decision, supported by parliament and the public. But Vattenfall, a Swedish energy company, operated 2 nuclear plants in Germany. Vattenfall filed an ISDS claim. They argued that the phase-out was an expropriation of their assets. They demanded compensation not just for the plants, but for the electricity they would have sold in the future. The claim amounted to nearly 5 billion euros. In 2021, the German government agreed to a settlement. They paid billions to energy companies to settle the dispute. Think about what that means. Taxpayers were forced to pay a foreign corporation for the privilege of enacting a democratic policy regarding national safety. This represents a transfer of sovereignty from the parliament to the boardroom. In the ISDS system, regulatory change is treated as a compensable injury. It functions as an insurance policy for corporations against democracy. But sometimes the legal war is even more aggressive. Sometimes it turns into a counterattack. Consider the battle between Chevron and Ecuador. This is perhaps the most complex instance of corporate lawfare in history. For decades, Texaco, which was later bought by Chevron, operated in the Ecuadorian Amazon. Indigenous locals alleged that the company deliberately dumped billions of gallons of toxic wastewater into rivers. They called it the rainforest Chernobyl. After nearly 20 years of litigation, an Ecuadorian court ruled against Chevron. The court ordered the company to pay $9.5 billion for environmental cleanup. Chevron refused to pay. They had already removed their assets from Ecuador. Instead of paying, they launched a scorched earth legal strategy. They sued the state of Ecuador at an international tribunal in The Hague. They claimed the Ecuadorian judgment violated a trade treaty. The tribunal ruled in favor of Chevron. They declared the Ecuadorian judgment fraudulent and ordered the Ecuadorian government to prevent its enforcement. But Chevron didn't stop there. They brought the war back to the United States, sued the plaintiff's lead lawyer, Stephen Donziger, under the RICO Act. RICO is a law designed to prosecute organized crime syndicates. Chevron argued that the lawsuit against them was a conspiracy. A U.S. judge agreed, finding that the Ecuadorian judgment had been procured through fraud. Donziger was disbarred and placed under house arrest. The corporation effectively criminalized the legal team that held them accountable. They used a U.S. court and an international tribunal to nullify the Supreme Court of Ecuador. This is super sovereignty. It is the ability to strip a national judicial system of its authority. It is a demonstration that a corporation can destroy the opposition, not just win the argument. While lawfare is the primary instrument of this silent takeover, we cannot ignore the physical reality. Kinetic force is still a necessary tool for securing assets in unstable regions. We are seeing the reprivatization of violence. We are moving back to the model of contract soldiering that characterized the pre-modern era. The wars in Iraq and Afghanistan catalyzed the explosion of the private military industry. Companies like Blackwater, now Academy, assumed roles that were once the exclusive domain of the military. By 2007, there were nearly 160,000 private contractors in Iraq. This was roughly equal to the total number of U.S. troops. Outsourcing allowed the government to wage war with a lighter official footprint, but it also created a vacuum of accountability. Contractors were often immune to local law. We saw this with the Nisr Square massacre, where Blackwater guards killed Iraqi civilians. This impunity mirrors the extraterritorial rights enjoyed by colonial armies. And in the extractive zones of the global south, the line between corporate security and state military is dangerously blurred. Multinational corporations employ hybrid security forces. Look at Shell in Nigeria. In the 1990s, the Ogoni people of the Niger Delta organized mass protests against oil pollution. They were led by the activist Ken Saro-Wiwa. They demanded a share of the oil wealth and the remediation of their land. Internal documents later revealed that Shell worked closely with the Nigerian military regime to suppress these protests. Shell was accused of providing logistical support and payments to the military units. In 1995, the Nigerian government executed Ken Saro-Wiwa and 8 other leaders. Decades later, Shell agreed to pay $15.5 million to settle a lawsuit brought by the families. They settled to avoid a public trial that would have examined their entanglement with the state's terror apparatus. Then there is Glencore in the Democratic Republic of Congo. Glencore is a giant in commodities, trading, and mining. The DRC is rich in cobalt and copper, essential for our tech economy. In 2022, Glencore pleaded guilty to a decade-long scheme of bribery. They admitted to paying over $100 million in bribes to officials across Africa and South America. They paid over $1 billion in fines. But beyond the financial crimes, their operations rely on security forces accused of human rights abuses. NGOs have documented security forces using excessive force against artisanal miners. The corporation secures the resource, while the violence required to maintain that security is outsourced. In Papua New Guinea, at the Porgera mine operated by Barrick Gold, the silent takeover manifested as brutal physical violence. For years, local women alleged they were subjected to sexual violence by mine security guards. Security personnel reportedly abused women found scavenging for gold on waste dumps. Barrick eventually acknowledged the allegations were credible and created a remediation framework. But the fact remains that a private entity was policing a population. When that policing turned criminal, the company administered its own quasi-judicial remedy system. This is the privatization of the state's core function, the monopoly on violence. G4S, the world's largest private security company, runs prisons. They manage the deprivation of liberty for profit. But perhaps the most sophisticated form of warfare is financial siege. This allows corporations to seize the assets of a state without firing a single shot. This is the world of vulture funds. These are distressed debt hedge funds. They specialize in buying the debt of defaulted nations for pennies on the dollar. When a country goes bankrupt, most creditors agree to a restructuring deal. They take a loss to allow the country to recover. Vulture funds do the opposite. They buy the debt specifically to sue for full payment. The conflict between Argentina and Elliott management is the definitive example. After Argentina's economic collapse in 2001, the country defaulted on billions of debt. Most creditors accepted a deal for roughly 30 cents on the dollar. Elliott management refused. They launched a global legal campaign to seize Argentine assets. In 2012, they did something that sounds like it belongs in the 18th century. They petitioned a court in Ghana to seize the Era Libertad. This was a 3-masted tall ship, a training vessel for the Argentine Navy. It was docked in a port in Ghana. A hedge fund successfully held a sovereign naval vessel hostage. The crew was forced to evacuate. The ship was held for 2 months. Think about the symbolism of that. A financial firm blockading a nation's military asset using a foreign court. Elliott management persisted in U.S. courts as well. They eventually secured a ruling that prevented Argentina from paying any of its other creditors until it paid Elliott in full. This forced Argentina into a technical default. In 2016, a new government capitulated. They paid the holdouts roughly $4.5 billion. Elliott management's return on investment was estimated at over 1,000%. This established a dangerous precedent. A single determined creditor can hold a nation's financial system hostage. It represents the privatization of sovereign bankruptcy. Profit motives override the macroeconomic stability of a G20 nation. The East India Company sought to control the trade of spices. Modern corporations seek to control the fundamental building blocks of life. We are seeing a form of biopolitical warfare. This utilizes intellectual property law to enforce monopolies over biological necessities. Consider the case of Monsanto versus Schmeiser. Percy Schmeiser was a Canadian farmer. He was found to have Monsanto's patented Roundup Ready canola growing in his fields. He claimed he didn't plant it. He claimed his fields were contaminated by pollen drift from neighbors. The Supreme Court of Canada ruled in favor of Monsanto. They held that by harvesting and saving the seeds, Schmeiser infringed on the patent. It didn't matter how the seeds got there. The court established that the patent on the gene extended to the plant itself. This effectively overturned thousands of years of agricultural tradition. It established that corporate property rights extend to biological organisms that self-replicate. If your field is contaminated by a corporate product, you don't own the crop. The corporation does. This is genetic feudalism. Farmers become tenants of the genetic code they cultivate. We see the same dynamic in the pharmaceutical industry. The TRIPS agreement globalized strict patent protections, forced developing nations to adopt U.S.-style patent laws. During the HIV/AIDS crisis, this prevented nations from producing cheap generic drugs. Millions died because they couldn't afford drugs priced at $10,000 a year. Generics could have been produced for under $300. When South Africa tried to amend its laws to import generics, 39 pharmaceutical companies sued. They used lawfare to protect monopolies at the cost of human life. The final frontier of this corporate sovereignty is the creation of new, explicit corporate territories. We are seeing the rise of digital colonialism in charter cities. Big tech companies exercise power that rivals nation-states. They control the information infrastructure. They extract data as a raw material, process it, and sell the insights. It mirrors the resource colonialism of the past, but the resource is human behavior. Meta, the parent company of Facebook, has created the Oversight Board. This is a body of experts empowered to overrule the company's decisions on content. Legal scholars compare it to a Supreme Court. It adjudicates the free speech rights of billions of users. It is a private polity governing a digital population larger than any country. It has bypassed the state entirely, creating its own constitutional law. And then there are the charter cities. ICE-backed entity that established a special economic zone on the island of Roatan in Honduras. It operates as a semi-autonomous city-state. It has its own legal system, its own tax code, and its own regulations. It allows businesses to choose which regulatory system they want to follow. It commodifies law itself. When the new Honduran government tried to repeal the law enabling this zone, calling it a violation of sovereignty. Prospera responded. They filed an ISDS claim for nearly $11 billion. That amount is equivalent to 2/3 of Honduras's entire annual budget. This is the apex of the silent takeover. The corporation is not just suing for lost profits on a product. It is suing for the right to govern territory. It is holding the national budget hostage to preserve a corporate enclave. It is a modern recapitulation of the East India Company model. A private entity administers territory protected by unequal treaties. Finally, we must recognize the most subtle form of takeover. It is not the confrontation of war, but the infiltration of the command structure. This is the revolving door. The influence of banks like Goldman Sachs is so pervasive, it is often joked about as government sacks. Alumni of the bank hold key positions in finance ministries worldwide. U.S. Treasury Secretaries and European Commission presidents have moved seamlessly between regulating the economy and profiting from it. We see it in food regulation too. Michael Taylor alternated between working for the FDA and working for Monsanto. During his time at the FDA, policies were enacted that benefited the biotech industry. This creates a cognitive capture. Regulators view the industry as a partner, not a distinct entity to be policed. Case's immune system is suppressed from within. The silent takeover is not a conspiracy theory. It is an observable, quantifiable restructuring of global power. The Westphalian system, based on the sovereignty of nation-states, is eroding. We are entering a neo-medieval era of overlapping jurisdictions. Corporations possess sovereign rights without sovereign responsibilities. The visible hand of the East India Company's army has been replaced by the litigious hand of the modern corporation. The soldiers are now arbitrators. The forts are shell companies. The territory is the regulatory landscape itself. Through ISDS, debt enforcement, and regulatory capture, corporations have constructed a legal cage around democracy. Citizens may vote for their governments, but those governments are increasingly constrained by the rights of capital. As Edmund Burke warned centuries ago, law and arbitrary power are in eternal enmity. Today, the arbitrary power of the corporate sovereign has draped itself in the robes of the law. The takeover is silent, but its consequences are resounding.